Hello, everybody. Today I have a short presentation on the proper execution of a last will and testament in the state of Alabama. Now, I have previously talked about how you can have virtual notarizations and witnessing pursuant to a special emergency proclamation issued by Governor Ivey related to the pandemic that we're under, and that is possible, assuming you follow those circumstances. But today's presentation is not about that. Today's presentation is about the standard, I want to call it normal, the pre-pandemic normal, where a last will and testament was executed in the presence generally of two witnesses and a notary public. I'm asked about this from time to time. I've done this probably hundreds of times myself. I've been practicing law for 35 years, and so I'm old. I've done it a bunch. And occasionally I'll be asked about someone executing a last will and testament, not in my presence, but in someone else's presence. And I've had notaries that have asked me about this type of execution and what they should look for, or just generally, I've had situations where before the pandemic, before virtual notarization and witnessing was permissible, where a client has asked me, maybe I'm in Birmingham, my client's in Mobile or Huntsville, and I have emailed the documents to them. They printed them out, comfortable with them, and want to go ahead and execute them before we can get together. And so I've sent them information on how to do that. So today's presentation is going to be concerning that kind of thing. Let me go ahead and share my screen with you. And let's see if we can get started with this execution of a self-proved will in Alabama. Now, I didn't mention the type of will in my little introduction, and a self-proved will is a particular type of will. And this particular type of will is one that requires the testator, two witnesses, and a notary, and to follow a special procedure outlined by the Code of Alabama. And I'm going to talk about that here in just a minute. You don't have to have a will, doesn't have to be self-proved in order to be a valid will. It can just be signed by a testator and witnessed by two witnesses. However, problems arise in that event. Let's look at the law first, and then I'll talk about that in just a second. The Code of Alabama Statute, section 43-8-132, basically is the self-proved will statute. I would say 99% of all wills prepared by an attorney, if not more than that, are self-proved wills, and that's a good thing. If you do not have a self-proved will, if you have a will that is signed by the testator and witnessed but not notarized, then it may be a valid will, but you have a problem. And the problem is that you cannot conclusively presume the validity of the execution and the signatures on that particular will without having a court hearing and a judge to take evidence and hear testimony and make a decision as to whether or not that will was properly executed and those signatures are valid and not the product of improper influence or any number of different things. Picture this. Will is prepared 1998. 22 years later, testator dies. Where are those witnesses? If it's not a self-proved will, you got to go find those witnesses from 22 years ago. I've had to try to find them from longer than that. Can you do it? It can be difficult. And if you can find them, you may have another problem. Do they even remember the circumstances surrounding that particular will execution? Do they remember the testator? Maybe they worked in a law office or a bank or someplace else and actually witnessed a number of different things. Or maybe they witnessed it, but it wasn't somebody they really knew. They met them for the first time for purposes of that will execution, and they just signed it and went on. The self-proved will statute prevents a lot of these problems because it says that if you follow the correct procedure, the will signatures will be presumed to be valid without the necessity of having a court hearing. So I know this is what you came for. Let's go ahead and look at what the law is as it relates to the execution and what you need to be looking for. The first one, and I'm going to, a couple things. I'm going to skip over this pretty quickly, the law pretty quickly, and focus on the execution. If you want the law, I'll be glad to send it to you. You can probably find it, or you can just rewind it and pull it from this presentation and the PowerPoint slides. But generally, the law requires for self-proved will for an oath to be given, administered by a notary, by an officer authorized to administer oaths, being the notary, under the laws of the state of Alabama. And the oath is being given to both the testator and the witnesses. First part is the testator's signature. And what I generally recommend is just reading this. I, the testator, I, Jane Doe, whoever the testator, sign my name to this instrument, this blank day of blank. And I pulled this directly from the statute. So that's why it says 19 something rather than 20 something, because it's been around for a long time. And being first duly sworn, do hereby declare to the undersigned authority, that's you as the notary, if you're in the notary, that I sign and execute this instrument as my last will, and that I sign it willingly. There's a parenthetical there I'm not going to focus on. I'll save that for another presentation, or willingly direct another to sign it for me. I'll talk about knotty problems and tricky situations in another presentation. But today's going to be your kind of normal one, that I sign it willingly, that I execute it as my free and voluntary act, and that I'm 18 years of age or older. So basically, by them signing this, they are swearing that all these things are true, which is part of the statute itself. Second part is the witness's signature. And again, witnesses' signatures are going to look like this, and I pulled this directly from the statute as well. At the end of today's presentation, I'll show you what one of mine looks like in a real live will. I just took the names out with that. I hope I took the names out. I did. And you have the witnesses that are signing after first being duly sworn. They declare, the testator signs and executes it as his last will. If you notice this, it says he sings it willingly. Again, that's their typo from the statute, not mine. I have, oops, going to go back. I have corrected that in my particular forms that I use. I'm not saying I'm perfect, but at least I don't have that typo in my particular form. As they do in the statute. And you see the rest of it. The witnesses go ahead and sign. And then your portion. And again, if you've been asked to notarize a will, all of this should already be in the form. There's just, in the will itself. I'm just trying to go over it to make sure that you're comfortable with it. It should look a little bit like this. Probably will look a little more like the will form that I use that I'll show you at the end of today's presentation. But this again came directly from the statute. The notary subscribed, sworn to, and acknowledged before me by your name, by blank, the testator, Jane Doe, whoever the testator is, not your name, and subscribed and sworn to me before by blank and blank witnesses. Those blanks are a lot longer than that in most forms because you need more than that to write Franklin W. Whipplestapper or whoever the witness is. This blank day of blank. and then your signature, and then official capacity of officer, notary public. I usually have notary public, and then pre-printed. My commission expires and have a place for the notary to actually handwrite in the expiration date of their commission in the event that it's not pre-printed on their stamp or whatever they are using. Okay, that's your normal kind of situation. I do want to go ahead and point out something else that comes up from time to time. And you may need to help educate the attorney if you have a circumstance like this. Let's say that you've been asked to notarize a will, but you arrive and doggone it, the witnesses and the testator have already signed. So they did not sign it in front of you. All is not lost. You can still have a valid self-proved will pursuant to the statute. You go to subsection B of the statute, and it says that an attested will, one that's been signed and witnessed, may at any time subsequent to its execution, meaning after it's been signed, be made self-proved by the acknowledgement by the testator and the affidavits of the witnesses, each made before an officer authorized to administer, blah, 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 the notary, that those things occurred in substantially the following form. So it looks a little bit different, but we blank and blank, blank, blank and blank, the witnesses, the testator and the witnesses respectively, whose names are signed and attached or foregoing instrument, being first duly sworn, do hereby declare to the undersigned that the testator signed and executed the instrument as his last will, and that he had signed it willingly or willingly directed another to sign for him, and that he executed it as his free and voluntary act, blah, blah, blah. Now, you really want to be slick and have this in your traveling kit. Might not be a bad idea to have this pre-typed and pre-printed and just have it with you in the event that you ever are called to notarize something that's already been signed, a will that's already been signed and witnessed. As I said, all is not lost, but you've got to use this particular form. And you see that I say lawyer should determine. Yes, the lawyer should determine, but you might want to have a conversation with the lawyer if they ask you to notarize it and say, hey, I can't notarize their signatures under the form that you've given me, that first one that we looked at, because it says they are signing it in front of me. They're acknowledging before me as they do that. However, take a look at this and see if this won't work. I understand that this came from the statute, and you can even have a copy of the statute handy. Might not be a bad idea. And again, you have this pre-printed, just state of Alabama, county of blank, as you know, that's where your feet are. And so that county may change depending on if you're traveling or not. And then have blanks for the testator's name and the witnesses so that those can be handwritten in. And then if that's the case, you can have the testator and witness. And again, you'd have to have this portion typed too. I just have extra copies of it if you were going to do a bunch of this, 3 or 4 extra copies, and hope it never comes up. And it was just 3 or 4 extra pages that you never ended up having to use. But you have the testator and the witnesses' signatures, and then your subscribed, sworn to, and acknowledged by me portion as well. And again, you would only use this second part in the hopefully rare circumstance where they call you to notarize a will that's already been signed and witnessed. They didn't do what they were supposed to do. Guess what? Lawyers screw up all the time. They do that kind of thing all the time. If you can help them out, you may have a client for life if that's the case. You know, hey, look, I can't do this. That's not proper. However, you know, I understand that. I'm going to go back up for just a second. I understand that I can use this particular form instead. Why don't you read it? Here's the statute. This is my understanding of what I'm supposed to do in the event that it has already been signed and already been witnessed. If you are in agreement with that, we'll go ahead and I'll administer the oath to the testator and to the witnesses and have them sign, and I'll go ahead and notarize. Now, if you follow the procedure properly in either A or B, the consequences are that compliance with the signature requirements under the law is conclusively presumed. You don't have that court hearing. You don't have to go, the lawyer doesn't have to go and track down witnesses from 20, 25 years ago and hope they can find the witness, and even more hope that they remember the circumstances. So it's a wonderful thing if that's the case, if you have a self-proved will. Now, I said that I would we'll let you take a look at one of mine. I'm going to let you do that right now. And here you go. This is an example of one of mine, and how that I do it. Jane Doe. Let me make that correction on the fly. The testator signed my name. You'll see it's very, very similar. It's almost identical. I typically, and I do this for a particular reason that I'm not going to really go into here, but you notice that I actually use 19 years of age or older. If I ever have someone that's 18 and they're signing a will, which is valid in the state of Alabama, I'll change that. I haven't done one for an 18-year-old. Everyone I've ever done one for has been over the age of 19 years or older. Usually substantially older than that. And then, but this is probably what it will look like in the event that you're actually doing one for a client, for witness or notarizing a will. You'll have hopefully it'll be filled in, but you want to make sure that it's dated. Then the testator is going to sign. The witness names need to be handwritten in here and then sign. Now, this portion here with the address of the witness is not required by the statute. Most lawyer forms that I have seen, including my own, have a place for the address of the witness. And the reason for that is just in the wild situation where somebody's alleging fraud or something like that, and you have to find the witness anyway, you might have a way of kind of tracking them down. Maybe, maybe not. Most of the time they have it. It's not required by statute. And then you have your portion, which is the notary section, the county, the state and the county. And then you have the, and you see it here, Jane Doe, the testator's name is actually typed in. Usually that's the case because you know who the testator is. The lawyer who writes the will knows who the testator is. Usually they don't know who the witnesses are going to be. So you have blanks for the witnesses. Those need to be filled out and dated. And then of course the notary with my commission expires at a particular time. So in any event, I hope that that has been helpful for you. If you have any questions, if I can ever help you, feel free to give me a call. My telephone number is there, and my email address in the event that you want to receive something such as the statute. If you wanted to see that, I gave the reference to it. And I think you can find it just fine, but in the event that you cannot locate that, or if you need a copy of something that's on here, feel free to contact me. Anyway, hope you have a good day, and again, hope this is helpful. Bye.